What do you do when the state wants to build a highway through the family farm? Stick around and we're going to find out. Hey guys, so welcome to another episode of Suits and Boots Legal Talk. I'm Luke Martin with Benbow Davidson and Martin. This is Scott Copeland, one of the attorneys there with us. And Scott's focus in practice is on eminent domain, which is, we're going to get into what that is because that's a weird word and something that a lot of folks have never had to think about. And hopefully you don't ever have to think about it, but when they do, we're here to help, and we want to help take care of folks. So, Scott, thanks for being here today, man.
I'm glad to be here, Luke. Thanks for asking me.
So let's talk about eminent domain. What in the world is that?
Okay, well, first of all, if I was to say anything about eminent domain, let's talk about the word eminent. There's two ways you can spell it. One way is the I-M-M-I-N-E-N-T. That means something's going to happen soon. That is not eminent domain. Eminent domain is E-M-I-N-E-N-T, like the word preeminent. That means it's above. It's a higher authority. And eminent domain is when the state or a municipality or a utilities company, if they have the right, can take property from a private property owner.
And this is something that's the state is typically, or a lot of times the state's the one doing it, or public utility or something like that, but it's actually baked into our federal constitution, right?
That's right. And, our founders were very smart. This is something that's been around for a long time. I think on the podcast we did a couple of weeks ago, I even mentioned that there's a biblical story of King Ahab and Naboth's vineyard. And so eminent domain goes back even to biblical times. And it's been recognized that sometimes a sovereign, a king, a governor, some kind of a ruler needs to take private property for some kind of purpose. And so our Constitution is a constitution of limited powers. That means that the framers understood that the government needs to do certain things, so they tried to hold those back. So in the Fifth Amendment, they said that no property can be taken except for a public purpose and with just compensation. And so they put a limit on what the federal government can do, and a lot of states have picked up stuff like that in their constitutions as well. But they understood that there's going to be times that, for various reasons, the government needs to have some property, but they want to make sure that, number one, you're compensated fairly, fair market value, or number two, it's got to be for a legitimate public purpose. It can't just be because the government wants it. Yeah,
so, and as we think about public purpose, I think one of the things that as I was growing up, I've always heard about eminent domain and how the government, well, and there's one thing that I really want to get in on here is because a lot of folks, I believe, think that if you don't accept the government's offer, well, they're just going to come in and take it and you're going to lose it anyway. And I want to get to that because that's really important and something we need to narrow in on. But what is the possibility, especially when thinking about public purpose and those kind of things? Is it possible to stop the eminent domain? Is it possible to keep them from building the highway through my property or putting the power line through there or whatever?
It can happen, but it's very, very rare. Generally, the most people are going to be affected by something that's like a road widening. Let's say they want to go and make a 2-lane road into a 4-lane road. That's going to be a public purpose because, we have folks moving here from all over the United States. In fact, all of the South. You're seeing that right now. It's a great migration, and we need infrastructure. So the government has to do these things to keep up with the amount of people. So it's going to be for a public purpose. A utility, because they're statutorily given the right to use eminent domain. They're not a government authority, but they're given that right. It's a delegation of it, is what it's called. And they have the right to do that as well because utility, getting power somewhere, getting water somewhere is going to be a public purpose. So it's rare, but there have been times when things have been stopped. And there's statutes that talk about that, but it's in the very rare case that it is.
So most of the time, you're not going to be able to stop whatever the project is, whatever's happening. The government is going to be able to push through and do what they want to do, and they will take the property. That's
right. Yeah. So they're going to come through, and if you want to, we can kind of go through how the process works.
Yeah. So if that's the case, if they're going to take the property, so I guess the myth, I'll call it, that I've heard my whole life is, well, you better take the money that the government offers because they're just going to get the property anyway. So, but that's not necessarily the case. I mean, they're probably going to get the property, but they're going to come with an offer and say, hey, we're going to pay you this for your property. I mean, should people be taking those offers?
I would recommend almost never taking the government's first offer. You got to realize they're coming in with they may be on a project and they have one appraiser doing a bunch of appraisals. you can't be sure that that appraiser, and they may be a great appraiser, but they've done so much work. It's a good idea to hire a lawyer to look at what's going on in this offer and see if they can do more for you. And generally, you're going to only get paid if the attorney gets you more than what they offered. So there's really no loss to you to at least take it to an attorney and say, hey, what am I looking at here? But almost always, that's a starting point for negotiation and nothing more from the government.
Yeah. So if you take that first offer, that's all you're going to get.
That's
but
right.
if you go back and you can negotiate that, and even if the government files a lawsuit, a petition of taking or whatever, what's it called here in North Carolina?
There's a declaration of taking, but it's the complaint is what, and they'll file that with it.
So once they file that, they're going to get the property, and probably not going to be able to stop that. And what are the circumstances in which you could stop the taking?
If it wasn't for a public purpose, sometimes the government may, and actually I don't know of a particular circumstance, but I know they've happened before, where they may be helping a private developer or somebody that is not the public, and may be not enough of a public purpose for it to be justified as that. Sure. And so then you can just challenge the take, and sometimes the government will say no. I mean, the courts will simply say no, stop it. This is not a take.
Okay.
Yeah.
So the government comes in, makes that offer. If they come to an attorney, everybody's always worried, well, attorneys are so expensive, it's going to cost a lot of money. What benefit do they have by coming and talking to you about this?
Well, first of all, we don't charge for a consult. If you can come, we'll sit down and we'll talk on the phone, or we can go through the documents you got from it's a right-of-way agent is what you'll get it from.
If it's an eminent domain consult.
Yeah, right, eminent domain consult, that's right. Yeah. And we'll talk through that. And then the way that we get paid is we get paid on a contingency. So we get paid a fee based on how much more we get you above the initial offer. So if we cannot increase the offer from the condemnor, then you owe us nothing at the end of the day. Do
you normally see an increase over the government's initial offer?
That's almost always the case. I don't know of a case where we ever ask someone to just, okay, this is as good as it's going to get.
Yeah.
And so I guess theoretically it could happen, but I haven't seen it happen.
So one of the things that we've heard from folks who we've talked to is, well, yeah, you might get me more money, but I'm going to have to pay you a big chunk of that. So does it make sense, and how does it make sense, I guess, for folks to come and talk to us, hire us to help with this eminent domain procedure, and then they do have to pay us a chunk of that? So how does that make sense for them to do that?
Well, it makes sense because the vast majority of folks out there that are property owners aren't educated enough to be able to understand what has to happen in eminent domain. It's not as simple as going to the bank and hiring an appraiser just to find someone to go out there and look at your property. There's a lot of things in eminent domain that only happen in eminent domain. We look at property not for what it's used for today, but what could it be used for. You deserve to be paid as much as if you wanted to sell it on the marketplace yourself and do that. There's things that it's called remainder damage, where not only do you have an easement across your front yard, but that also makes the rest of the property worth less money. Yeah, you deserve to be paid for that, because if 15 years down the road you go to sell the property and someone comes in and says, well, I like this property, but if I compare it to the one down the street, I'll give you 20% less because otherwise they're identical. You deserve to be paid for that today, and you get one shot at it. So it's always good to make sure you do it right the first time around.
Yeah, so when we talk about remainder damage, like that easement across the front yard, let's say that the government has, or DOT or whoever it is, puts that easement across the property. What does that mean for the property? What does that easement do to the property?
An easement gives someone, the easement holder, the subservient estate, or if it's what we call an easement in gross, that someone can come onto the property and do something, which is mainly what the DOT has. But that gives them the right to come on the property pretty much whenever they want. So that means you've lost one of the bundle of sticks, which is the right to exclude. That's one of the foremost rights that people have in property, is the right to kick someone off their property, but now you can't. So however big the easement is, they can come on there. They could put a utility line on there. They could put a drainage easement. They may be able to put 2 utility lines. They could come back in 10 years and put another utility line on there. And if you don't watch what's going on, that's the kind of thing you want to check in the first place. And that's why you need an attorney too, to look at the documents and say, these are the rights they're trying to get. How do we can we limit those, or can we make sure you get paid for them? Yeah,
one of the things that stuck out to me, you and I were just in a CLE in Raleigh for which is continuing education for attorneys. We were just in a meeting in Raleigh talking to a bunch of guys who do this kind of work. And one of the guys was talking about this ability, if a utility has an easement across your property, or DOT has an easement across your property, they can enter into your property really anytime they want to do maintenance or whatever they need to do on that easement. And one of the things he said was that people don't think about this until there's somebody walking through their front yard. Privacy is security. That's somebody walking through your property, and you have no right to go out there and tell them to leave because they have a right based on that easement. The other thing it does is it limits your ability to do things with that easement, right? I mean, it's your property. You still pay taxes on it. You still have to mow the grass. You still have to do all the maintenance on it, but you can't use it, right?
That's right. Most of the easements that I've seen almost always have a clause that say something like they can be used for any use except for that which the condemnor decides is detrimental to its own use. So most of the time it's kind of arbitrary. So even the condemnor, let's say it's a municipality, they can say, well, I don't like you parking that heap right there. That's getting in the way of our drainage easement. So you got to move it. And there's not much you can do because it's left up to them to decide that. So they can limit it, and maybe you can park right there. Maybe you can drive over it. Maybe not. Depends on what the easement says.
Yeah, one of the easements we were looking at not long ago was, and I think this may be in Mecklenburg County. I can't remember for sure, but the easement was going across the backyard of the property. And one of the things that we thought about immediately was a swimming pool. Yeah. If this person wanted to install a swimming pool behind their house, it's no longer an option, right?
That's right. In fact, usually the easements will even say that. You can't put any kind of water structure on there or a swimming pool across that. And if you have an easement that cuts across your backyard, now you split your backyard in two.
Yeah.
And you have a part of your backyard that really is not going to be used much for anything except running around on if you got kids or dogs or something.
I've heard an easement like this is a lot of times described as a fence. Like it may not be a physical fence, but it's a legal fence that really divides your property into two different places because you've got the property on one side of the easement, property on the other side, and that little strip in the middle that you can't really do as much with as you can the other stuff.
Right. So that's what we think about the term remainder damage, because it's not just what's being taken. There may be a 50-foot easement, and the condemnor will say, well, we think your property is worth X dollars an acre, and we're taking so many square feet, we're going to pay you for that. Well, you got to think, well, this property behind here, that's on the other side of my easement is now worth less money. What is my house worth less money? And you got to think about those things. Once again, you only get one shot at it. Because
once you settle, it's over, right?
Once you sign that release and you say, I release all claims against the condemnor, then you can't come back again, and unless there's something egregious that goes outside of that. But for the most part, that's it.
And this is why I think for me, I'd never really gotten into this kind of law until I met you, and you've been doing this for like 6 or 7 years now.
Right.
And so for me, I really would never, even as an attorney and even as a real estate attorney, I never would have thought about this. Like remainder damage, what in the heck is all that? So if someone would have come to me before meeting you and before starting into this type of law, I probably would have thought, well, yeah, we just need to value the property and figure out what it's worth. And that's one of the things that I think we've seen DOT do is take a little small strip of property off of your front yard and say, well, your whole property's worth this much. We're only taking this little bit, and so we're going to pay you a prorated value for this little bit of property because we're only taking this little bit. But they hardly ever talk about the damage that happens to the rest of the property or the diminution in value to the rest of the property from that little take.
That's right. So. I see this a lot in residential takings where they'll acknowledge that there's a house on the property, but then they'll say in the appraisal, but we don't see any damage to it, so we're not going to bother to value the improvements on there. Whereas a property owner's attorney is going to get, if you need it, is going to get you an appraiser that knows what he's doing and can and sometimes they may be right. It could be so far away, maybe it's not really going to damage the house. I mean, but if it's in the front yard and you're 50 feet away from the front door of your house is worth less money.
Yeah, sure.
in the marketplace. And I think most reasonable people that are in the marketplace understand this.
Well, and let's talk about this too. If especially one of the most common areas where we see this is a road widening project. And so you've got a 2-lane road in front of your house, and now you're getting ready to have a 4-lane road. And so we know that, what is it? It's some hugely high number, like 80% of the houses in America are on a 2-lane highway. And now your house is going to be on a 4-lane highway. And what is the damage to that? That's a huge thing. Who wants to live on a 4-lane highway?
Especially people with kids or dogs.
Yeah,
I mean, don't, if you have small kids, and that's twice as much traffic coming through there, more or less.
Yeah.
And you just feel safer with a 2-lane road most of the time.
Absolutely. So these are all things that we have thought about, and you especially spend hours and hours and hours of every day thinking about this. And so for a homeowner or even a business owner or someone like me who, as an attorney, I would have probably thought, I'm sophisticated. I can do this. I've been to law school. But really, if I would have tried to do this before getting into it with you and starting down this road with you, I would have been way over my head. And so for a homeowner to think, I'm going to do this on my own, I'm going to negotiate with DOT and their team of lawyers in Raleigh, and it's just unfathomable to think that you could be able to do that.
Oh, they'll negotiate with you, but it'll be for a very small increase, and it probably won't anywhere near what the actual taking is worth.
So as we start into negotiations, one of the things that we got to determine is like this just compensation idea. So it's not necessarily even fair market value, is it? Because anybody can determine what's fair market value for this property. But what is the difference between fair market value and just compensation?
There's not always a real defined difference, but there's the way that they look at it in North Carolina and in federal law too, is they look at what's the property worth before, what's the property worth after. The question in eminent domain is you want to look at what is a willing buyer and a willing seller. What are the things that they would think about? You know, if you went out into the marketplace and you said, I want to sell 50 feet off my front yard, what kind of things would you consider? Would you consider how much closer that's going to put your property line to the house? Would you consider, maybe my house is worth less money now? What's going to be able to be used on that? Those are the things you would think about. So you should be compensated at the same level that that you would be if you wanted to sell it yourself, not under the threat of condemnation. You know, a condemnor might say, if you don't do this, we're going to take this. Well, that's not the same thing. You need to make sure that you're getting compensated fairly. And it's why you want to get someone that has experience in this, that knows what they're doing, that knows the ins and outs of this. And not every attorney, that even real estate attorneys, are going to be able to do these things. So it's helpful to get someone. But that's the theory behind just compensation. Theoretically, the idea of eminent domain is to make you whole like it never happened. You can't do that. I mean, you're literally taking property. You can't give property back. There's only so much property. But the idea is to get compensated at a fair amount, which is what we call just compensation.
Yeah, so if the other thing, you've mentioned this as we've been talking here, but this idea of highest and best use. I think I heard you say that just a little bit ago. So talk a little bit about in the just compensation realm, what does it mean that we got to value it at its highest and best use?
Right. And that's just fair to the owner when you think about it. So let's say you have farmland that would be great for development. So you don't have to sell the property or value the property like it's just agricultural property. You can you value it if there's a reasonable probability, and that's the standard for getting it rezoned to whatever that is, and then those are things. And North Carolina courts have said this, that as long as there's reasonable probability of rezoning, that can be taken into account for evaluation of the property. So you would sell it as if you were selling it to a developer, not if you were selling it to another farmer.
Because if you had a farm and you had farmland and you were ready to sell it and you wanted to maximize how much you would get for it, and it's reasonably probable, or likely, that you would get it rezoned, that's what a normal person would do. Hey, I want to get the most money for it, so we can get it rezoned to commercial or whatever, and get more money for it. That's the idea, right?
Exactly. And you see how it keeps coming back to what does the market do? How does the market? How would people in the marketplace act? That's the way that the condemnor should act. And sometimes it takes the courts to enforce that. You know, because condemnors don't always come in and do things in the most fair way. So you want to make sure that's why, and what's interesting is you have your average property owner who's never thought about these kind of things until my boss used to say, no one thinks about eminent domain until it happens to them.
Sure.
And then you go, oh, wow, I got to learn about it, right? And it's never actually happened to me. I've never had my property taken, but I've been around it a lot. So, but you're thinking about what are the things that, and I lost my train of thought here. Now I got off on a tangent there.
Yeah, nobody thinks about it until it happens to them.
Nobody thinks about eminent domain. So, and I know I've gotten off topic now from where I was, but
well, we have so many people that come in, and we're doing this all over the state of North Carolina. So it doesn't matter whether you're in either in Murphy or Manio. I mean, we're either any of those places. We're everywhere between, and we can do this and we can help in any of those places. Right. But talk through just a little bit the process. I've gotten an offer from DOT. They've come in, they want to take my property, and it's likely that they're going to be able to do it. And we say DOT because they're typically the ones building roads. But it could be Duke Power, it could be any number of folks. It could be the city of Statesville where we're sitting right now, or Raleigh or Charlotte, or any of those municipalities or public agencies. They're coming in to take the property. Usually that starts with a letter from the DOT. Maybe an offer, and then what do we do? What's how does that process play out? What are the next steps there?
Right. So if you know that there's a probability of a taking coming soon, and you've not even been contacted by the DOT, get in touch with us. I mean, call us. There are things you can do to get ready for a taking. It's good to have an attorney before they even get to your front doorstep. But once they show up, so let's say that you've already hired us, and then here comes the DOT right-of-way agent, and I say right-of-way agent. So the DOT apparently used to do it themselves, but switched before I came to North Carolina, and they hire third-party right-of-way agents, and their job is to come in there and get you to sell the property. And so they're going to show up, they're going to have an offer, and generally they'll have an appraisal to tell you how they appraised the property, how they got to their numbers, and then they'll give that to you and say, okay, think about this and get back to us, and then they'll start calling you fairly often to keep checking on you. What we'll do is we'll take that offer, we'll evaluate it, look at it, and then we will see if we can go on your behalf back to the right-of-way agent and see if we can get something done to be able to get a full compensation or just compensation for you. And if that doesn't work, then generally we'll move into the litigation stage, and that's to me where it gets interesting, because it's not just throwing numbers back and forth, but a lot of people get a little bit scared because it is litigation. I mean, someone's getting sued, but you're not in trouble. The government needs your land. No one's going to jail over this, hopefully. And which, by the way, we don't really want to do criminal law if we don't have to.
Right,
so,
that's
right.
Yeah,
I don't do it, so we'd have to get you somewhere else.
We'd have to get Daryl involved.
There you go. Don't want to. And he's excellent, but we'd rather keep him out of that.
Yeah.
So. But then what they'll do is they'll file the complaint, the declaration of taking, and that's what we call a quick take. And when they file that, what they're going to do is they're going to file the deposit, which is the amount of money that they've said that the property is worth. Now, they may have negotiated a little bit and gone up $10,000 or something. They're going to deposit that original amount, not whatever the last settlement offer was. So they're going to deposit that amount. When they deposit that amount, the statute in 136 says that they automatically title vest in them for those rights. So whatever they're asking for, permanent easement, temporary construction easement, drainage utility easement, right-of-way, and a fee take, then that automatically becomes theirs. They can start their project.
And that's so that a property owner can't hold up the project, right?
Yeah,
so you can't be the last holdout, and DOT or whoever's just having to wait years and years until they can get something worked out with you. They can start pretty much immediately.
That's right. And you got to think that kind of is fair to the government, because if not, then we'd have all these projects where one guy sat and said, I'm not taking any offer you give. That's what they call a slow take. And that's another way of doing it as well. You don't see those very often. We get involved in all that. And it's really, in our experience so far, and probably I think your experience as well, your highest offers are going to come after litigation. I mean, it's very rare to settle before something's filed, right? I've not seen it happen yet. I've not had a great deal of success trying to settle in pre-litigation. That's
one reason I think it's really important for you guys to reach out to us, because it's one thing to say, yeah, I'll negotiate with whoever, with the person who's taking my property or the government entity that's taking my property. And you can do that, but eventually, if you want to get the most bang for your buck, if you want to get the most money out of this deal, it's going to end up in litigation. It's going to end up in court. And that's where we live. That's what we do. And that's something that we think about constantly, all day, every day. And for someone who doesn't do that, it's got to be really intimidating and almost impossible to do if you're not in that world like we are.
It is. There's a lot of things that just a layperson may not know about doing that. One thing that you said, it always ends up in court. Yes, it'll end up in the court, but not necessarily in trial.
Sure.
We're willing to go to trial. That's part of our fee. We get paid, based on the end result, not how many hours we put in. So The great part is, so Luke, if someone hires me, then they can call me every day if they want to. I'm not billing them by the hour. They can call me and just say, hey, what's up, Scott? And I'll say, hey, what's what's up? And is anything new? Nope. All right, good to talk to you.
Yeah.
But I still get paid the same amount. So I'm not on a retainer. I'm not on a per hour billing for that. I do other stuff that is, but that's not it. But almost 99% of cases do not go to trial.
Yeah.
A lot of times sometimes the threat of litigation is enough to get the condemnor to move to a better number.
Yeah.
And sometimes you gotta push that far to get something. The key in eminent domain really is patience. If you want to get something done next week, we can get something done for you, but you're not going to get what you get if you're willing to wait, a year, 2 years while the project happens. And while you're watching your front yard get torn up, and you may have some money in the deposit, but it's not enough. I'm going to go back real quick and say that when they file that complaint, once you get served, you have a year to answer. The statute's very generous to give you a year. As long as you file an answer within that year, then you can still keep fighting for more money. So you're not being held back from getting the maximum value for your property. It just allows the condemnor to go ahead and start with their project without being held up.
Just because they filed and they get title to the property, they've got the property, that doesn't mean that's just really the beginning.
That's right.
We begin to negotiate and work through, and we go through a process in North Carolina, and it's not just in these type of cases, but it's in most of our cases. We have a process called mediation, which is where the attorneys go and sit down with the clients, and we try to work something out. It's exactly what it sounds like it is. We try to mediate or settle the case before it gets to trial. Sometimes we go to trial, and that's okay. That's what we do. And like you said, it doesn't cost the client any more money for us to go to trial than it does for us to settle it the day after they call us. So it's good to get involved with us early and let us get involved and help with these things. If you're a commercial person, it's probably, if you've got commercial properties, we represent some people with gas stations. We represent some people that have Dollar Generals on their property. If you have those type of situations where you've got multiple commercial properties, you need to call us now. Even if you're not involved in any kind of condemnation, because the chances are you will be, because those properties are on major highways and those things are always being widened or something like that. So that we need to get in touch with those people sooner rather than later, don't we?
Absolutely. The damages to a commercial property can often be pretty consequential because, if they're taking part of your parking and you're not going to meet code anymore for the city, or if your lease with your tenant says you have to have X amount of parking spaces for how many square footage of the building there is, you may be in breach of the contract. And so you need to start thinking through these things. And maybe you need to work, if you have a national tenant, work with their legal to try and figure out, hey, how are we going to approach this? And you need to be ready for when the DOT shows up. You're not going to be running, okay, this is what they want. We have a pretty good idea what's about to happen beforehand. And so we can start preparing, how do we want to make sure the property is ready for when they do come and ask for it?
Yeah, exactly. So one of the things you alluded to earlier, and we'll end on this, is time. Patience is key. A lot of these cases will go on for years, right? So if you want to settle soon, it's going to cost, right? It's going to cost us money. So the key is patience. I mean, are we talking like 6 months, a year, 2 years? What do you see in these things?
It's usually a year, maybe a couple of years. You have a year to answer, and a lot of times, the DOT, I know, for instance, likes to wait that year, make sure everything vests in them, and then they may start doing it. Sometimes they want to wait till the project is done, and then you can really say, okay, these are my damages. They're somewhat hypothetical a little bit if the project's not done yet, but if you do the project, then it's that here's what it is. Here's exactly how my business has been damaged. My property's been damaged, not business damage, but property damage. And so I can get paid for this. So sometimes, it may take 2 or 3 years and some of them have gone on for longer than that.
Yeah.
But
so it's the key is patience.
That's right.
And our job as your attorneys is to maximize the amount of money in your pocket. And so we want to help. And people get frustrated because the wheels of government turn so slow a lot of times, and it takes a long time to get these cases done. But the longer and the more patient we are, many, many, many times, the more money we make off of this, and the more money you guys get to put in your pocket. And that's really what we want. They're taking your property. You need to be compensated for that. So, Scott, thanks, man. I hope this conversation was helpful to these folks.
And I remembered what it was I was talking about a minute ago when I lost my train of thought. The purpose of the courts is to protect your rights. So the condemnors, a lot of these guys, they'll come in. They have a lot of money. I mean, they can come in with multiple appraisers, multiple engineers, and the property owner doesn't have the money to hire, the appraiser. And so we can take it to the court and say, court, these are the rights that they have under the statute. And I don't care how many experts the other side has, they're going to hold you in an equal standing with them at that point right there.
That's right.
And so so that's one of the great parts about litigation, is that the government's there to protect your rights in your property.
Which is interesting. We go against the power of the sovereign. We go against the power of the government. And that's one of the things that I think you and I really like about this is we're saying to the government, no, you can't do that. You got to pay for it. And the DOT has and the condemnors have a duty to try to limit the amount of money they spend, because that's taxpayer dollars. But at the same time, if they're taking your property, then you need to be compensated for that. So we want to help with that. So, man, thanks so much for the time today. And guys, if you know of someone who's looking at, oh my goodness, the government's coming to take my property. If that's you, share this video. Make sure to get it out there to people, because we want to help, especially North Carolina cases, even not North Carolina cases. If you've got questions, we know attorneys all over the country who do this work. We're part of organizations with people who are into this every day. We want to help, so make sure and share this video, like and subscribe to our YouTube channel, our Facebook page, and stay up to date with everything we're talking about. So this is one of the topics we're covering, but there's so many things that our firm does to help you guys. We're here to help, and we want to be there for you in the times that are hard, the times that are tough. We can handle these things and take some of the load off of your shoulders. So thanks for watching, and you guys have a good one.
The information contained in this video and audio recording is general in nature and should not be relied upon in making legal decisions. Every situation is different, and you should consult with your attorney before making any legal decisions.